All right, Deputy Minister, are we ready with anyone?
Yes, sir, we are. We've got Mr. McConaughey here in place of Mr. Bolton with Mr. Pedro Nino.
All right. All right, this is cause number CR 21301, State versus Pedro Olivares Nino. And we're set for plea today. Are we doing the plea today?
No, Your Honor. That was our fault. Mr. Bolton, Ms. Curry made an offer to Mr. Bolton. Her understanding was that she never received a confirmation of acceptance back with that, and because of that, we have not yet met with the victim's family. So Ms. Curry is requesting an additional reset of 30 days so that we have the opportunity to sit down with the family of the deceased victim in this case.
Was the proposed plea for time, or was it for probation, or what?
Time, Your Honor.
Time. And is the defense opposed to this request for continuance?
No, Your Honor. The offer has been relayed to the defendant, and defendant is amenable to taking it, but if the state needs time to speak with the family, we're fine with that.
How long are you asking to have it reset, Ms. Heisel?
Your Honor, we would ask for 30 days, but if the court wants to set it sooner than that, we'll do our best to get the victim's family in here as soon as possible.
I think sooner is better, just because if he's going to accept a different type of sentence for time, then we can go ahead and start that process and get him where he needs to go. How about February 22nd? That would give us a little less than 2 weeks, but
I believe, Judge, that we could probably get Ms. Cheney to set up something before then. We'll make it happen.
okay. And does the defense have any scheduling issues with February 22nd in the afternoon?
We can make it work for the afternoon, Your Honor. Either myself or Mr. Bolton will arrive.
Okay. All right, then we'll reset this for plea on February 22nd at 1:30.
May I be excused, Your Honor?
Yes, thank you, Mr. Conte. I appreciate it.
Thank you, Your Honor. See you in 2 weeks.
We have anyone else that's ready?
Sorry, Your Honor. Ms. Chester, are you ready? Sorry, Your Honor. We've got Ms. Chester who's here and ready with her client.
All right, this is cause number CR 16633, State versus Chelsea Lee Caver. This is hearing on motion to revoke.
That's correct, Your Honor. I spoke with the DA this morning. We are waiting on medical records to be sent to us. We needed a release, and Ms. Caver just came back to Van Zandt County from Henderson. She just got here, so we haven't been able to get that release sent off. So we just need a reset in order to get those records and get them to the DA.
Do you know about how long you might need?
The caseworker that I talked to said once they got the release, it should be maybe a week or so before we got them. She said that they were already compiled. We just needed the signed release.
I could either set it on the contested docket in 2 weeks, or the next available after that would be March 10th.
Okay, we can do the 2 weeks and hopefully they'll be there by then.
All right, we'll set this on the contested docket on February 24th at 1:30. And Ms. Chester, on those contested docket days, the inmates will be brought over to the courthouse, so it will be in the courthouse at 1:30.
Perfect. Thank you, Your Honor. May I be excused?
Yes, ma'am. Thank you.
And Your Honor, Officer DeBoard is working on bringing up some additional bodies, but he's not ready just yet.
Okay, all right.
Thank you.
I mean, I ought to not do it because I'm jealous of her, but
Your Honor, we do have two counselors who have quick appearances and they're ready if you want us to visit with them.
Good.
Ms. Beasley?
Good afternoon, Judge.
Good afternoon. Do you have Ms. Rios?
I'm supposed to judge, but she did not make an appearance. We were set for a plea, but she's not here, and I believe the bondsman has filed an ATGOB.
All right, the court will grant that and we'll see if we can get Ms. Rios scheduled against her will.
Understand, Judge, and if I may withdraw on that case, because there's a good chance she won't be here in the next couple of weeks.
All right, court will grant your oral motion to withdraw. Ms. Beasley.
Thank you,
Judge,
Judge.
that's how we kept Miss Beasley. You just let her off the hook.
Yeah.
I'm an
State has- State has many objections to this.
Yeah, she's already ex parte me on it, so she's good to go.
Thank you, Judge.
You're very welcome.
Mr. Wright?
I hate it more than y'all do, trust me. Let's see, who do you have, Mr. White? I don't show you on my docket.
Your Honor, I have Oscar Robles.
Yep, there you. All right, this is cause number CR 16557. Mr. Robles is set for pretrial. Go ahead.
Your Honor, this is a rather old case. And Ms. Curry and I were talking about it yesterday. There was multi-agencies involved with this. One of them I know was the ATF. And I've got some concerns about discovery. I'm going to have to sit down with the DA's office and make sure I got everything. After I reviewed it, I'm concerned that there may be some audio visual things that didn't make it into the file. I won't need very long, just 30 days. I've explained that to Mr. Robles. Obviously he wants me to do the job that he retained me to do. So I'm just going to ask for 30 days so I can make sure I got everything.
All right, court will reset Mr. Robles in for an additional pretrial. Are you available on March 10th, Mr. White?
Yes, sir.
All right, we'll set Mr. Robles for pretrial on that date at 1:30 if he's in jail, 9 a.m. if he's on bail.
That's all I have.
Thank you, Mr. White.
Thank you, sir.
Deputy McLeish.
Yes, Your Honor, we got Mr. Barentine are ready, sir.
Okay, well, I was gonna let you know that I do have Mr. Craddock from Mr. Ashmore. I believe I have Ms. Thompson. I think her identity on the line is Mihal Larson. I think that's her. And I have Thomas Ashworth. So those attorneys are present in the online waiting room. So they're
Okay. Thank you, sir.
All right, this is State versus Joseph Lee Barentine. Go ahead, Mr. Kimball. I showed that we were set for plea. Is that right?
That's correct, Your Honor. And Mr. Barentine has completed the plea paperwork. And I only have one correction I'd like to get on the record. The time served, the credit at the bottom left of the plea paperwork. His paperwork was printed last month, and due to timing issues, he should have basically another 30 days credit. So it says 181, which should reflect 210 approximately.
My paperwork that I have here shows 219.
Oh, then that is correct, Your Honor.
Is that right?
paperwork we signed is old. It was printed last month.
Okay, well, so just for the record, it does show 219 days. The judgment that I'll sign will say that. So you can review that judgment there, but the one I signed will say 219 days, Mr. Barentine, okay?
Thank you.
All right, Mr. Barentine, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may put your hand down. Speak up loudly and clearly for me, okay?
Yes, sir.
All right, Mr. Barentine, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Brent Gimble. Are you satisfied with his representation of you?
Yes, sir.
Like you've had enough time to discuss all of your cases with him, and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed that you do not understand?
No, sir.
And where you did sign, you're swearing that that is your true and correct signature, and you only signed once you were satisfied you understood what you were signing.
Yes, sir.
Mr. Gimble, do you believe your client to be competent?
I believe he is, Your Honor.
And you've explained to him all of his legal rights?
I have.
And you believe he understands them?
I believe he does.
All right, Mr. Barentine, it appears in cause number CR 21277, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in prison and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
I see the plea agreement in your case is that you will plead guilty to that charge in exchange for the state's agreement to recommend that punishment be assessed within that range of punishment at 3 years confinement in prison, a $3,500 fine, $180 restitution, $290 court costs, and $90 reimbursement fees. In addition, I see that the state is asking the court to dismiss under section 1245 two charges, those being a possession of controlled substance, penalty group 3 misdemeanor, and also an accident involving damage to a vehicle less than 200, which is also a misdemeanor. Is that your understanding of your plea agreement, Mr. Barentine?
Yes, sir, it is.
Yours as well, Mr. Gimble?
It is, Your Honor.
All right, so understanding the plea agreement, understanding the range of punishment, Mr. Barentine, how do you plead to possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams?
Guilty.
Mr. Barentine, are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Gimble, any objection to state's evidence?
No objection, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of Mr. Barentine's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense, Mr. Gimble?
Nothing for defense, Your Honor.
Take just a moment and review the evidence. All right, Mr. Barentine, I've reviewed the evidence. I do find enough evidence in your case to convict you. The court will follow the plea agreement that you've reached with the state. The court hereby convicts you of possession of a controlled substance, penalty group 1. Court assesses your punishment pursuant to the plea agreement at 3 years confinement in the Texas Department of Criminal Justice Institutional Division. Court assesses a fine of $3,500. Court cost of $290, reimbursement fees of $90, orders you to pay restitution of $180, and the court takes into consideration and dismisses the previously aforementioned cases, possession of controlled substance, accident involving damage to a vehicle less than $200. Mr. Barentine, the court will award you 219 days credit towards your sentence for the time that you have spent in jail on this cause. And you are hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over to your right with the deputy so she can get your fingerprint. Once you do get out of prison, Mr. Barentine, I'm going to order you to report to the Van Zandt County Courthouse so that you can make arrangements to pay off your fines and fees, okay?
Yes, sir.
All right, good luck to you, sir.
Your Honor, that's all I have this afternoon. May I be excused?
Yes, sir. Thank you, Mr. Gilmore.
Mr. Burgess.
Whenever we have a little lull, I'll grab the employment.
Ma'am, thank you.
She's going to be on the week. Oh, okay.
Who do we have here?
Your Honor, Mr. Burgess with Miss Ann Thompson.
All right, this is cause number CR 21-8, State versus Troy Wayne Burgess. Mr. Burgess is on the status today, Ms. Thompson.
Yes, Your Honor, it is for a plea, Your Honor. The paperwork was already turned in on.
Okay. See if I can-
And Judge, I gave that to Mr. Abraham to be taken over to the jail. I'm pulling up right now so I can read you the terms of it, but the actual paperwork is at the jail, or it should be.
Your Honor, that is correct. We have paperwork for Mr. Burgess here.
And then Judge, I'm ready if you are.
Yes, ma'am. I'm ready.
Okay. To the charge of aggravated assault with a deadly weapon, upon a plea of guilty, the state agrees to abandon the enhancement paragraphs as listed in the indictment. We agree to punishment assessed at 10 years, probated for 4 years, and a fine of $2,500. No restitution, but $290 court costs and $1,340 reimbursement fees. I also do not have any jail time credit listed for Mr. Burgess for this plea.
And there's no jail time as a condition of community supervision or anything like that?
No, Your Honor. The victim of this crime is Mr. Burgess's father. If you will recall, Mr. Burgess's father brings him to court and helps him get around since he suffered a stroke. The elder, Mr. Burgess, has specifically requested this plea agreement.
Ms. Heisel, due to the state abandoning the enhancement paragraph, does that in any way at all change the second degree level of the offense that I see on my docket? Is it still second degree assault deadly weapon?
Yes, Your Honor. With the enhancements, I believe it was a 25 to life case that we agreed to abandon because of Mr. Burgess's medical issues.
All right, thank you. All right, Mr. Burgess, can you see and hear me okay?
Yes, sir.
All right, Mr. Burgess, I want you to hold on to that podium, but best you can, just raise your right hand for me so I can place you under oath. Mr. Burgess, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Troy Wayne Burgess, is that right?
Yes, sir.
And Mr. Burgess, are you a United States citizen?
Yes, sir.
And do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you are represented by your attorney, Miss Ann Thompson. Are you pleased with her being your attorney?
Yes, sir.
And do you feel like you've had enough time to talk with her about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork, Mr. Burgess, that you've signed today that you do not understand?
No, sir.
All right. And Ms. Thompson, do you believe Mr. Burgess to be competent today?
Yes, I do, Your Honor.
And you've heard Ms. Heisel recite the terms of the plea agreement. Is that your understanding as well, Ms. Thompson?
It is, Your Honor, and I did go over that with Mr. Burgess.
All right, thank you. All right, Mr. Burgess, you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine not more than $10,000. Do you understand that range of punishment?
Yes, sir.
And you heard the prosecutor read to me what the conditions were on your plea agreement. Is that what you understand them to be?
Yes, sir.
All right. And so understanding the plea agreement and understanding the range of punishment, Mr. Burgess, I'm going to ask you right now, how do you plead to aggravated assault with a deadly weapon?
Guilty.
All right. And are you pleading guilty to that charge because it's true that you are guilty of committing that crime?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead guilty today, Mr. Burgess?
No, sir.
All right. The court will accept the defendant's plea of guilt. Ms. Thompson, any objection to the state's evidence?
None, Your Honor.
All right. State's evidence is admitted, and the court does take judicial notice of Mr. Burgess's judicial confession. Anything further from the state in addition to the summary of the evidence?
Your Honor, I would just say that the state has received an affidavit of non-prosecution on this from the father who is the victim. So we are in victim compliance, but there is no victim impact statement for the court to review. And then as far as the evidence before the court, when this offense occurred in 2020, Mr. Burgess was 58 years old. He went to his 79-year-old father's home, his father and mother's home. He was yelling and threatening to kill them, and he had some sort of axe or hatchet. They locked themselves in the home and called 911. When police arrived, they observed what was consistent with an axe or a hatchet marks on the exterior of the home where Mr. Burgess had tried to get into the house. There was also an eyewitness who confirmed the parents' story that Mr. Burgess had threatened to do them harm while wielding that object.
All right, Ms. Thompson, any objection to that narration?
No, Your Honor.
And I recall, and maybe I'm incorrect, but was there some type of intervening health event with Mr. Burgess? Did he suffer a stroke or anything of that nature during the pendency of this case?
Yes, Your Honor. After his arrest, while he was on pretrial, he did suffer a stroke. The state has received medical documentation through Ms. Thompson from his doctors regarding his prognosis. And that is part of the reason for the dropping of the enhancement paragraphs and the offer of probation as well in this case.
All right, thank you, Ms. Heisel. Is there anything further from the defense, Ms. Thompson?
No, Your Honor, we would rest.
All right. Then based on the evidence as it has been presented to the court finds that there is sufficient evidence to convict Mr. Burgess of this crime. The court will follow the plea agreement. The court hereby convicts Troy Wayne Burgess of aggravated assault with a deadly weapon, a second-degree felony. The court assesses his sentence at 10 years confinement in the Texas Department of Criminal Justice. The court will suspend that sentence, place Mr. Burgess on community supervision for a period of 4 years, order him to pay a $2,500 fine, $290 court cost, and $1,340 in reimbursements to Van Zandt County. Mr. Burgess, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence. I'm going to have you go with Deputy McLeish there to your right. She's going to take your fingerprint. After that, you can speak with one of the probation officers who's over there, and they'll give you more information, okay?
Yes, sir.
Thank you, Ms. Thompson.
Good. Yes, sir. Good luck, Troy.
Thank you, Ms. Ann. Your Honor, Mr. Mitch Adams will be with you shortly with his clients.
Okay, I'm gonna go ahead and bring in Mr. Ashworth, that doesn't have a client there, so. Good afternoon, Mr. Ashworth.
Hello, Your Honor.
We're checking in for our monthly Zoom meeting, you and I.
Yes.
Do you have any, this is on CR 2349, State versus Carlton Mitchell. I verified that he's still in custody, Smith County. Do you have any further information for the court regarding his status in Smith County?
Some, yes. So he has signed plea paperwork and I've signed them. We've turned them into the prosecutor. We're waiting for the prosecutor in Smith County to give them to the court. Then I'm told the next step is this court is going to schedule us for a Zoom plea and then we're good to go.
Okay. And what type of plea is that over there? Is that for time or probation?
Yes, it's time.
It's for time. Okay. All right. And so do you have any time frame when you would expect maybe that Zoom plea?
No, Your Honor. I called the court yesterday and all they could say is that they're waiting for the prosecutor to give the paperwork to them. And I just couldn't tell you when that's going to happen, but I know that we've done everything on our end.
Sure. Okay. Are you available on March 10th? That's another 30 days. Maybe that'll happen in that time period.
I believe so. Yes.
Okay. So let's do this. We'll set him March 10th at 1:30. And if the plea doesn't happen, then we'll just, hopefully it will in the next 30 days. But if it doesn't,
I sure hope so.
we'll do our next Zoom meeting.
As soon as it's done, I'm going to let Ms. Heisel know in case y'all want to put a bench warrant on him so he doesn't get shipped off to TDC and then have to come back to Van Zandt.
Yes, please do. Yeah, you can let Ms. Heisel know, or you can let my coordinator, Ms. Tabraham, know. We can do a bench warrant or a hold. And yeah, we definitely don't want to have to go down to TDC and pick him up.
No. All right.
All right. Thank you, Mr. Ashworth. I appreciate your time
Thank you
today.
as well.
Mr. Adams, who are you ready on?
Oh, this is a Teresa Villanueva.
CR 21-271, set for docket call.
Yes, sir, Your Honor. No issues to take up with the court today. Obviously, no pretrial issues. Ms. Villanueva was recently rearrested, January 25th January. I was unaware of this until today. So we've got a plea offer from the district attorney's office. I would like to have some additional time so that I can maybe convince them to see the way of light and justice more than they presently are. So if we could set this to another docket call, that's what I'd ask the court to do today.
State, would you like to retort?
I have no objection to Mr. Adams trying his very best.
All right. So how long? I can have you back here in 2 weeks.
What would the date be?
It could be February 22nd. If it's just a plea, we could do it on the 24th.
I can't represent to you, Judge, that I know it will be a plea. So you said 22nd or 24?
Well, that's if y'all have something worked out. We need to
Okay.
resolve it. If not, then we can set her on.
Yeah.
We've been setting you for April though. I'd hate to set her out that far.
Okay. How about, take care of it as earlier in the week, so February 22nd, I suppose.
All right, we will set Ms. Villanueva for an additional docket call on February 22nd. That'll be at 1:30. This is CR 21-214 State versus Stephen Foster for a docket call.
Afternoon, Your Honor. No issues to bring up with the court at the moment. I think I have a plea offer from the district attorney's office. I'm still not completed going through all of the discovery to my satisfaction yet in order to have the conversation with Mr. Foster that I need to have about whether I think he should take his plea offer or whether we should go another route. And I know that we're here for a docket call today. I don't know with what I have coming on the second half of this month that I can do what I need to do by the 22nd or the 24th. If the court, I know I'm asking a lot, but I'm asking the court to set us for a docket call on April, whatever that April date is.
State, do you have an opinion?
State has no objection to Mr. Adams' request for a reset. We did relay an offer. I would give him time to relay that to the defendant, go over whatever evidence he feels like he needs to go over.
Mr. Woodwhite, when did you make the offer?
December 13th.
Okay, so it's been quite a while.
Well, Judge, you've got Christmas, you've got New Year's, you've got my near-death experience with COVID. So many things have taken a valuable time in the interim.
And is that offer from the state, is that for time or probation?
It's an offer for time, right?
Yes, Judge.
All right, the court will set Mr. Foster for his final docket call on April 12th.
Yes, sir. Thanks, sir. Mr. Schultz. Mr. Schultz.
The state versus Billy Joe Schultz.
Afternoon, Your Honor.
CR 21-243, 2025-13, docket call in each case.
Yes, sir. Judge, in a break from my past announcements, I'm happy to advise the court that we have reached a plea agreement with the state. We'd just like to get this set for a plea hearing as soon as the court is available so that we can take care of Mr. Schultz's business and get him on down the road.
Okay, we'll set Mr. Schultz in for plea on February 22nd at 1:30.
That's the 22nd, Your Honor?
Yes, sir.
Okay. Tells us that's Judge, I think that's all I have for the afternoon.
Yes, sir. You may be excused.
All right, thank you. Good to see you.
Your Honor, there is a medical issue that's got our hallway congested for just a moment. So as soon as we get somebody up, it'll be Mr. Schmidt with his client, Mr. Mercer. It's going to be a couple of minutes.
Okay, and who's the gentleman there in the back?
This is Mr. Perry. He is here.
Yeah, let's go ahead and bring Mr. Berry in. Good afternoon, Mr. Berry. All right, this is cause number CR 21279, State versus Grayson Tyler Berry. Mr. Berry, you have been indicted with a third-degree felony offense of possession of a controlled substance and penalty group 1 greater than or equal to 1 gram, but less than 4 grams. That type of third-degree felony carries a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine of not more than $10,000 if you were convicted and sentenced. Okay, so in this case, do you intend to hire an attorney? You have an attorney, and who is your attorney?
His is John McGrath.
John McGrath. And is he aware of your setting today?
He is, I believe so. I haven't had contact with him. My father has. And from what I understand, that John called up here yesterday, but he's based out of Houston. So I don't know how that's all working with him.
Well, and your family or you have retained him, y'all paid him money and engaged him?
Yes, sir. Yes, sir.
Okay, all right, and so it's John McGrath. Do you know how that's spelled? Is that McGrath?
I believe so. I believe so.
All right, well, I'll tell you what, have a seat and we'll see if we can get a hold of Mr. McGrath and possibly have him zoom in so we can have an announcement on your case, okay?
The only person I know who would have his phone number is my father. I know my dad would answer.
Okay, well, we'll look him up online and try to talk to Mr. McGrath directly, okay? Thanks, sir. Just have a seat. We're going to stand in recess for a few minutes so I can follow up on that information with Mr. McGrath, and then we'll be right back.
Yeah, right. This is not normally what the afternoon looks like. I'm supposed to be here. But get on time. Oh, well. Get on time. Sorry, Rachel, that might have been something I could have helped you with. I don't know, there was something wrong with the cells down there. Of course, I can't hear what's going on. I just saw the nerves in the bodies and the code disappeared. Well, who's carrying you that you're over here?
Just getting ready for vacation. I was just gonna say that.
Who are you? Willis. Willis, one have seen who are you? Wilson. Wilson. We'll check on the things that are. Yes. Thank you for that. Super score. Super score. It'll be going on too, so. That's okay. Is Mr. Burns done now? Yes. Thank you.
Mr. Schmidt, are you ready?
Oh, sir. If you need to see.
Mr. Mercer?
Mr. Mercer.
I just want to make sure that I'm right. Is Mr. Mercer's middle name Keth, Keth, or is it Keith and it's missing a letter?
Should be Keith.
Should be Keith. Yeah, I think we probably need to fix that otherwise. Let's see, this is for time, so he's gonna go down there and he would create an AKA for him.
Yeah, that'd be correct, Judge. And it's the same, I just noticed it's the same on all of the documents. Except for-
Mr. Woodwhite, could we,
Judge, we will revise at minimum, the judgment with the correct spelling of Mr. Mercer's name.
Mr. Schmidt, if you want to interlineate the rest of the documents, the stipulation of evidence, the plea admonishments, anywhere else, just not the judgment.
Yes, sir.
Interlineate it, and then he can initial that. We'll get the front page of the judgment fixed. That way it doesn't create an issue at TDC.
Okay.
Mr. Mercer,
Yes, sir.
you'll raise your right hand, sir. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Douglas Keith Mercer, is that correct?
Yes, sir.
Mr. Mercer, this is cause number CR 20264. Mr. Mercer, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Oh, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed with Mr. Schmidt that you do not understand?
Oh, sir.
And did you sign throughout the documents and placing your true and correct signature and only doing that once you were satisfied you understood what you were reading and signing?
Yes, sir.
And Mr. Schmidt, do you believe Mr. Mercer to be competent today?
I do.
You explained to him his legal rights
I have.
and you believe he understands them, correct?
Sure.
Mr. Mercer, you are charged by indictment with a state jail felony offense of possession of a controlled substance and penalty group 1 less than 1 gram. That does carry a range of punishment of not less than 6 months in prison or more than 2 years in prison and a fine of not more than $10,000. Do you understand that full range of punishment?
Yes, sir.
I also see that the plea agreement you want to enter into with the state today is that you're going to plead guilty to that charge, and the state's going to recommend that you be convicted today of that offense and that you be sentenced to 9 months in the state jail division of TDC with a $1,000 fine plus restitution, court cost, reimbursement fees, and that you would receive 211 days credit towards that sentence for the time that you have spent in jail on this cause. Is that your understanding of the plea agreement?
Yes, sir.
All right, so understanding all of those things, at this time, Mr. Mercer, I'm going to ask you, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
Mr. Mercer, are you pleading guilty to that crime because it's true that you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, Any objection to the state's evidence?
No objection.
State's evidence is admitted. The court does take judicial notice of Mr. Mercer's judicial confession. Anything further from the state in addition? Well, actually, I've already got the summary here, so I can read that. Is there anything further from the state?
No, Your Honor, we would rest and close. I'm also emailing Mr. Schmidt and Ms. Taberham a corrected judgment with his correctly spelled middle name. So be looking for that if you would, Judge.
All right. Anything further from the defense, Mr. Schmidt?
Nothing further.
Let's take a quick review of the evidence. All right, the court has reviewed the evidence. I do find sufficient evidence to convict Mr. Mercer of this offense. The court will follow the plea agreement that Mr. Mercer has reached with the state. The court hereby convicts him of possession of a controlled substance of penalty group 1 less than 1 gram, assesses his punishment at 9 months confinement in the state jail division of TDC, orders him to pay a $1,000 fine, $180 restitution, $290 court costs, and $35 reimbursement fees. Court awards Mr. Mercer 211 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Mercer, I'm going to have you go with the deputy to be fingerprinted. Once you get out of prison, I'm going to order you to report to the Van Zandt County Courthouse so that you can make a payment arrangement to discharge your fines and court costs and other fees, okay? Your failure to take care of those things could result in the court issuing an arrest warrant for failure to pay fees. Do you understand? So once you get out, just report to the courthouse and tell them you want to make payments on these things, and they'll set you up on a payment plan. Okay. All right. If you'll go with the deputy, be fingerprinted.
County have, I was taking control of your gun.
All right. I'm ready when you're ready.
All right, Your Honor, Mr. Ashmore's client's in the room.
Right again.
Mr. Wilson?
Wilson or Williams?
Wilson.
All right, Mr. Craddock, this is Damian Ray Wilson, CR 2234 and CR 2373, set for arraignment today. Mr. Wilson, the court has appointed Mr. KC Ashmore as your attorney. Mr. Ashmore is unable to be here today. However, he is having his associate stand in for him. This is Mr. Joe Craddock. Mr. Craddock, have you or Mr. Ashmore had an opportunity to review the indictments with Mr. Wilson?
Not at this time, Your Honor.
All right, give me a few minutes and I'll pull that up.
Mr. Craddock,
Yes, sir. Or yes, ma'am.
I stepped away for a moment and I think we've reached a stalemate. What are we doing right at this moment?
Judge is pulling up some documents to be able to review.
Okay, thank you.
All right, Mr. Wilson, can you see this document here?
Yeah, I can.
All right, I'm gonna give you a moment to read that. Tell me when you're ready for me to scroll down.
Excuse me?
Read what you can and then tell me when you're ready for me to scroll down so you can see the rest.
So you can scroll up now.
Have you had time to review that, Mr. Wilson?
Yes, sir.
All right, Mr. Wilson, is your name spelled correctly in the body? Don't pay attention necessarily to the top as much as right down here in the very middle where it says Damian Rabels. Is your name spelled correctly there?
Yes, sir.
And you understand that you're being charged with a third-degree felony offense of bail jumping and failure to appear?
Yes, sir.
Okay, I want you to understand the range of punishment if you were convicted and sentenced on that offense. The range of punishment that your sentence would have to fall within would be not less than 2 years in prison or more than 10 years in prison, and a fine of not more than $10,000. Do you understand that?
Yes, sir.
Okay. Now I'm going to close this one. I'm going different. All right. Can you see that document as well, Mr. Wilson?
Yes, sir.
Go ahead and read that and tell me when you're ready for me to. Not really the whole thing. All right. Have you reviewed that document?
Excuse me?
Have you reviewed the entire document?
Yes, sir.
Okay, and in this document, this is the indictment, cause number CR 2234. You're being charged with a third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram or less than 4 grams that does carry a range of punishment the same as the other case, not less than 2 years in prison or more than 10 years in prison. A fine of not more than $10,000. You understand that you're being charged with possessing methamphetamine.
Yes, sir.
And that amount was between 1 gram and 4 grams. You understand that?
Yes, sir.
Okay. And so, Mr. Craddock, you want to enter a plea in for Mr. Wilson at this time?
Yes, Your Honor. We enter a plea of not guilty.
Or will enter Mr. Wilson's plea of not guilty, find that he misspoke correctly in the indictment. We will set this matter for pre-trial. Mr. Craddock, I believe we set Mr. Ashmore on his cases this morning on, looks like we set on March 8th. I'm a little reluctant to new cases to set it that early for him. Remind me what his conflicts were that, does he have any conflicts with April 12th?
April 12th, if you give me one moment, I can double check his calendar. I know the next 2 weeks in March are pretty busy, but
Yeah, I can set it March 10th. Next time after that would be April 12th. So you'll check which one's better.
sorry, Your Honor, I'm having trouble hearing you. You sound kind of robot-y.
Is this better?
Yes,
Is it better
Your Honor.
now? Yeah, so if you'll look at either March 10th or April 12th or April 14th, which one of those may be better for you?
April
March
12th is open at this time.
Okay, we'll go ahead and set then Mr. Wilson for pre-trial on April 12th at 1:30 if he's still in jail. Mr. Wilson, if you ever make bail on these cases, then your court hearings will always be at 9 a.m., okay? And they'll be here in the courthouse.
Mr. Willis, come on up, sir.
This is cause number CR 19-211, State versus Kendrick Willis. Mr. Willis is set for docket call on his driving while intoxicated, 3rd or more. Go ahead, Mr. Craddock.
Yeah, so Mr. Willis, we have not received an offer. We're still negotiating with the prosecutors on this. We understand that Mr. Willis at a time had trouble meeting his bond, but that's because he was at inpatient treatment. So while there may have been check-in terms in his probation that may not have been met, it was due to the fact that he was seeking treatments for the issues that got him here in the first place. And so we would like some time to meet with the prosecutors and see if we can get an understanding, keep him on probation, given the fact that the reason these were missed was because he was in a facility treating the core problem and was unable to check in at these moments.
State any opposition to additional docket call?
Judge, I would ask this be set for the February 24th contested, if that works for Mr. Ashmore. That day, I haven't seen what they're talking about, so I don't want to say I can't be moved, but I think a short reset would answer those questions one way or the other.
Okay, this doesn't appear to reflect as an MTR on my docket, but both of you are telling me it's a motion to revoke case.
My documents were completed.
Your Honor, I believe it's a current case, a non-pled case, but it is an older case. That one of the issues Mr. Ashmore and I was having in my offer was the period of time that Mr. Willis was appearing to have been absconded. Obviously, if there's documentation of where he was at that time, that might influence my offer. And I think that that's what Mr. Craddock and I are discussing.
So it's not an issue of revocation of probation. It was an issue of pretrial release.
I believe so, Your Honor. I remember what my offer is off the top of my head, but Mr. Ashmore and I have had several conversations about this. I don't remember exactly where we are in negotiations, but I do think that I'm pretty set in my offer, absent some compelling evidence. So I think a short reset opposed to a long would get us somewhere.
Mr. Craddock, do you know if Mr. Ashmore could be available on February 24th? That's 2 weeks from today.
24th, would this be an afternoon?
It would be afternoon at the courthouse.
Yes, he appears to be available for that, and we can definitely provide documentation on this front in the course of negotiations.
Okay. All right. Then, Mr. Willis, we'll reset your case until February 24th. That's 2 weeks. We'll bring you over to the courthouse and see where the prosecutors and your attorneys are on the case. Okay.
Did you want to see my documentation?
Not me, not at this time. That's going to be between your attorneys and the prosecutors.
Okay, thank you, Judge.
You're very welcome. Right. Are you Michelle Stokes?
Yes, sir.
All right. This is cause number CR 2018, State versus Michelle Nicole Stokes. And this is a hearing on motion to revoke. Any announcements, Mr. Craddock?
Your Honor, we will have a contested motion in this matter. It was my understanding, I was with Ms. Stokes on Tuesday and she was set for bail or set for bond, but that was in Judge Winter's court. At that time, we were told that there would be nothing holding her, currently still in jail. I see that that's not the case at this moment. But yeah, for the motion to revoke, we would like to set a contested hearing for that.
Look at your case real quick. Now, is there an agreement with regards to her bail amount on the felony case?
Not on the felony case. I suppose because it was this one's in your court and not in Judge Winter's court that we couldn't find documentation on it. It was unclear because we have not seen the motion to revoke yet at this time. We were told that we're resolving everything that we could at the moment. And there's an agreement on, I believe the misdemeanor for $1,000 bond. And I'm not sure that everything had entered the system between Tuesday and today.
I do have an order setting bond here that's been given to me, but it's got both cause numbers on it, and it does say $1,000. But the bail set on the felony case is $50,000. So if this is an order that needs to go downstairs to Judge Winters so that she can have the $1,000 bail on her misdemeanor case, if y'all agreed to that, I can direct my coordinator to send that down there. But I just need a clarification on that.
Judge, the state's not opposed to $1,000 on the misdemeanor. However, we would oppose $1,000 bond on the felony.
Okay, so I'll just mark out the felony case number and I'll send that down to Ms. Anthony. She can present it to Judge Winters. And they may inquire, because it's not signed by either one of y'all, they may inquire about y'all's agreement on that. All right, so with regards to the contested hearing, we can do that in 2 weeks, if y'all believe that gives you enough time to prepare, or the next one would be March 31st.
Would 2 weeks, would that be the February 24th?
Correct.
Yeah, we'll be prepared at that time.
State.
Judge, I believe we could also be ready by that time.
And we'll set Ms. Stokes then for contested hearing on the motion to adjudicate and revoke to February 24th. That'll be at 1:30, Mr. Craddock, and it will be here in the courtroom.
Okay, Your Honor.
Right. All right, Ms. Stokes, we'll see you in 2 weeks.
But you're gonna have to speak to him separately, and you can contact him.
And Judge, as I understand, this is all of Mr. Ashmore's matters for this afternoon.
Yes, sir. I believe that is all I have for Mr. Keith Ashmore.
At this time, may be excused.
Yes, thank you, Mr. Craddock.
Thank you, Judge.
You can speak with your attorney this time.
Deputy McLeish,
Yes, Your Honor.
I see that Mr. Barry's back there. He can stay right there. So we have tracked down the attorney. And maybe I misheard you, Mr. Barry. I thought you said John McGrath, McGrath, but that's not correct, is it? It's John like LaGrappe or LaGrappe, LaGrappe. Does that sound right? So I believe he's going to try to join us online here in just a moment. So as soon as he comes in, then I'll call you up and we'll have a hearing on your case. Okay.
Your Honor, I do have Mr. Brad Rodriguez in the room.
Okay. Yes. Bring Mr. Rodriguez in.
Come on up, sir.
All right, Mr. Rodriguez, this is cause number CR 2269. The state has filed a motion to revoke your community supervision. And so I need to know at this time, are you requesting a court-appointed attorney? Are you going to hire your own private attorney? Or are you going to represent yourself?
I'll represent myself.
You'll represent yourself?
Yes, sir.
And are you familiar with the laws and the rules of evidence?
A little bit.
A little bit? Have you ever represented yourself before in a criminal action? I can't hear you.
No, sir.
You have not. Okay. So what laws do you believe that you are familiar with enough to represent yourself on a motion to revoke on a second-degree felony, which carries a range of punishment of not less than 2 years in prison or more than 20 years in prison if you are revoked and sentenced? Do you think that you're skilled enough to oppose the legal action of the state of Texas?
No, sir.
So do you have the ability, or does your family have the ability to hire an attorney to represent you?
No, sir. I guess.
Okay. Are you currently working? Do you have any money in the bank?
Yes, sir, I do. I got a check at Denny's right now. I speak it.
How much is that?
Right now I got like probably about a $900, $800 check.
Okay. Did you have any money saved up before you went into jail?
No, sir.
Do you have any assets, vehicles, homes, firearms, anything like that that you can sell?
No, sir.
Okay. So you're going to have to fill out the request for a court-appointed attorney, and you're going to have to list all of your finances and your bills, and then I have to evaluate that to see if you are eligible under the law. Okay. So that form is going to be out there at the jail. Just tell the deputy, and we'll get the jail
I
staff.
already filled one out already.
When did you fill it out?
Well, whenever I got here, my attorney was Bill Stevens.
Your attorney when you on your case before you got put on probation?
This was Bill Stevens.
Right, but so once you get put on probation, he's no longer your attorney.
Okay.
And if you get rearrested on a motion to revoke, like you have, then that's a whole new criminal action, and you have to start that whole process over again. Have you filled out a new request?
No, sir.
Okay, so we're gonna have that form brought to you. You fill that out, and then we'll talk again here, here in just a little bit. Okay.
Yes, sir.
All right. Have a seat. We'll have that paperwork brought to you.
All right, thank you, sir.
Yeah, actually.
I'm ready for you. Deputy Police, I'm ready.
Okay, sorry, Your Honor. Mr. Sanders is in the room and he is ready with his clients. The first one that's present is Mr. Laney.
Right, this is State of Texas versus Christopher Glenn Laney, CR 21298.
Mr. Lane, come on up, sir. Stand at the podium.
All right. Mr. Laney, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Do.
All right, you may put your hand down. Just speak up loudly and clearly for me. Before I proceed any further, Mr. Sanders, this looks like it's a plea agreement, state jail felony, 18 months, suspended, placed on 2 years community supervision, fine, restitution, court costs, reimbursement fees. Does that sound correct?
That is correct, Your Honor. And actually, Judge, we haven't gotten the probation conditions done yet. We actually just got done filling out the other paperwork. I just walked back in here. We can still, I don't know if we need to wait and get that part done before we actually do the hearing, or if we can do this now and get the probation conditions signed afterward.
Mr. Laney, have you ever been on probation before?
Yes, sir.
Have you been on probation in Van Zandt County?
No, sir.
Where were you on probation at?
Dallas County.
How long ago?
I believe it was 2018 was my last, 18,
So-
19.
So you understand the concept of community supervision.
Yes, sir.
You understand that there's going to be terms and conditions that prevent you from doing certain things.
Yes, sir.
You understand that if you do certain things, that's a violation of your community supervision, you can be brought back to court.
Yes, sir.
So what I'm going to do is I'm going to go ahead, since you've been on probation before relatively recently, I'm going to go ahead and proceed with the plea, and then I'm going to let you sign your community supervision conditions after that. But what I want to assure Mr. Sanders is that you go over those with him today, and if there's an issue, then I want to talk about it today. What I don't want to hear is, I didn't sign my conditions of community supervision. I didn't understand that I couldn't go to the VFW and drink, or I didn't understand that I couldn't go to the casino. I didn't understand that I couldn't go to Oklahoma without getting permission. I don't want to hear any of that. So I'm going to go ahead and go forward with the plea, and I'm going to take Mr. Laney at his word that he understands. But I want all that issue, any of those issues to be addressed today rather than later. Okay.
Okay, that'd be good.
All right, Mr. Laney, are you a United States citizen?
Yes, sir.
All right, actually, I don't know if have I sworn you in? Did I just swear you in?
Yes, sir.
All right. You are a United States citizen. Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Bipolar.
Are you currently on any type of treatment or medication for bipolar?
No, sir.
Do you feel like your bipolar disorder is in any way affecting your ability to have a rational understanding of what's going on in court today?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed that you do not understand?
No, sir.
And when you have signed this paperwork, you're telling me that your true and correct signature, and you only signed once you understood what you were signing.
Yes, sir.
Mr. Sanders, do you believe Mr. Laney to be competent today?
Yes, sir, I believe he is.
You've explained to him his legal rights.
Yes, Your Honor.
You believe he understands them?
Yes, I believe he does.
All right, Mr. Laney, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. That does carry a range of punishment of not less than 6 months in prison or more than 2 years in prison, and a fine of not more than $10,000. Do you understand that?
Yes, sir.
Any sentence that is handed down by a court or a jury would have to fall somewhere within that range. And you heard me read the plea agreement on the record earlier. Is that correct?
Yes, sir.
And is that your understanding of the plea agreement and what you want me to approve today?
Yes, sir.
All right. So understanding the plea agreement and the range of punishment, Mr. Laney, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you committed that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Sanders, any objection to the state's evidence?
No, Your Honor, no objection.
State's evidence is admitted, and the court does take judicial notice of Mr. Laney's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense, Mr. Sanders?
No, Your Honor, we rest and close.
All right, I'm going to take a quick review of the evidence. Mr. Laney, I've reviewed your evidence. I do find sufficient evidence to convict you of this offense. Court will follow the plea agreement that you've reached with the state. Court hereby convicts you of possession of a controlled substance in penalty group 1 less than 1 gram. Court assesses your sentence at 18 months confinement in the state jail division of TDC. The court will suspend that sentence and place you on community supervision for 2 years. Court orders you to pay a $2,500 fine, $180 restitution, $290 court cost, and orders you to reimburse Van Zandt County $640. Mr. Laney, you're hereby remanded to the custody of Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of your sentence. I'm gonna have you go with the bailiff to be fingerprinted, and then you'll talk with the probation officers, and you'll finish your conditions of community supervision. Okay, sir?
Thank you.
You're welcome. Do you have anyone else you're ready on, Mr. Sanders?
Yes, Your Honor. I think I have my other 4 all in here now, so.
Let's do Terry Vance. Is that still going to be a plea today?
Yes, Your Honor.
Got that paperwork here. Come on up, Mr. Vance. All right, Mr. Vance, if you'll raise your right hand. Other one. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, let me put your hand down. Your name is Terry Glenn Vance, is that right?
Yes, sir.
And Mr. Vance, are you a United States citizen?
Yes.
And do you read, write, speak English?
Yes.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In both of your cases, you're represented by Mr. Jeff Sanders. Are you pleased with him as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk to him about your case and have all your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read and signed with him today that you do not understand?
No, sir.
And where you signed in these documents, you're telling me that that is your true and correct signature, and you only signed because you knew what you were signing.
Yes, Your Honor.
And Mr. Sanders, do you believe Mr. Vance to be competent today?
Yes, Your Honor, I believe he is.
And you've explained to him his legal rights, and do you believe that he understands them?
Yes, I believe he does.
Mr. Vance, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle. And the range of punishment for that kind of offense is a minimum of 2 years to a maximum 10 years confinement in prison and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, Your Honor.
I see that the plea agreement in your case is that you would plead guilty to that charge in exchange for the state's recommendation that your sentence be set at 6 years confinement in TDC, a $5,000 fine, plus restitution, court cost, reimbursement fees. And you would receive 232 days credit towards your sentence for the time that you spent in jail in this case. Is that right?
Yes, Your Honor.
And the state is also going to be dismissing a filed charge, another possession of controlled substance case, CR 2140. So if that's your understanding of the plea agreement, I've explained to you the range of punishment. Then tell me, how do you plead to evading arrest or detention with a vehicle? Pleading guilty to that, Mr. Vance, because you are guilty of committing that crime.
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty today?
No, Your Honor.
All right, the court will accept Mr. Vance's plea of guilt. Mr. Sanders, any objection to the state's evidence?
No objection.
State's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, we'd rest and close in both cases.
Mr. Woodwhite,
Yes, Judge.
see here in the indictment that there's an enhancement paragraph?
Yes, Judge, I believe there is. It should be enhanced to a second degree. Does the judgment not reflect that?
No, sir, it says third degree. That's why I admonished him on third degree. It's within third degree punishment range, but I didn't know if there was an agreement on abandoning the enhancement paragraph, or otherwise we need to change the judgment to second degree.
Judge, we had not discussed, it's within the punishment range of both the third degree and a second degree. We had not had an agreement to abandon. It doesn't change the punishment range.
And Judge, Mr. Vance talked about punishment range. He understands it could be anywhere from 2 to 20 years. I did notice that when we were going over the paperwork, the judgment still had it shown as a third degree, but I told him that he could still be punished in the punishment range of a second degree felony. And so that's something where if we need to change the judgment, that's fine. Whatever we need to do to make that work.
Well, if we change it, I need to admonish him
Okay.
judicially of a second degree. I mean, I know he understands it, but I think it's incumbent upon me that I have to do that. Is that what the parties want me to do?
Judge, if you would, and I will reform the judgment to reflect it as a third degree enhanced to a second degree punishment range, we will send that to both Mr. Sanders and to the court for everyone's review.
And then we'll need a finding of true on the enhancement paragraph, and I'll need to go back and have him plead to that as well.
Yes, Judge.
Okay, so Mr. Vance, I need to back up, and I know that Mr. Sanders has already explained some of this to you, but I'm going to walk you through it again, okay? So in your indictment, I'll tell you what I'm going to do. Let me pull this up. Do you have that indictment there, Mr. Sanders?
Yes, sure.
All right, if you'll show that to him for me. There at the bottom is an enhancement paragraph that begins with, and it is further presented that. If you read that enhancement paragraph, there's another charge that's alleged that you have been convicted of, specifically CR 17-215, here in this court in Van Zandt County in November of 2017. The state's alleging that you were convicted of manufacture or delivery of a controlled substance in Group 1, 400 grams to 200 grams. Do you understand that?
Yes, sir.
Okay, so in that indictment, the underlying charge of evading arrest or detention with a vehicle is a third degree felony offense in the state of Texas. And it carries that range of punishment that we talked about earlier, not less than 2 years or more than 10 years. That means your sentence could be any greater than 10 or less than 2. However, with the state alleging this paragraph in your indictment, that would increase the punishment range in your case. And that would change the minimum from 2 to the maximum of 20. That means the sentence could have been anything between 10 and 20 years. The state's not changing their plea agreement. They're saying that it's still going to be 6 years in prison. However, what's going to be reflected on the judgment is that you're going to have been convicted of a second degree felony offense, okay, based on this enhancement paragraph. So what I would have to do, and I'm going to do it this time, Mr. Vance, is I'm going to ask you, after you review that enhancement paragraph, would you be pleading, would you tell me that the enhancement conviction and that cause number, that information is true or not true?
No, sir. I was not convicted of 400 to whatever that was. I was convicted of possession.
I don't think I think it ended up being reduced at the time
Yes,
that you
sir.
pled, so that it wasn't manufactured, delivery, or possession with intent. I think it was just a regular possession.
Yes, sir.
It was still a conviction at that time with that cause number. I just don't think it was actually manufacturer delivery.
All right, I'm going to show on the screen CR 17-215. That's the offense alleged in the enhancement paragraph by the state. It says November 9, 2017. It says possession of a controlled substance rather than manufacture or delivery. So Mr. Vance is pleading not true to the enhancement paragraph, and based on this, the court would not be able to find that enhancement paragraph to be true.
Judge, I believe, given that there's a issue with state's indictment, we're comfortable, given that information, abandoning that, allowing him to proceed on the third degree as the paperwork shows, in lieu of delaying the process, amending or somehow fixing that indictment to reflect what he was convicted of. Given that the state's agreement is still within the punishment range for both, we're comfortable with proceeding as the paperwork currently shows, with state abandoning enhancement paragraph 1, allowing him to plead to a third degree, remaining on the same plea agreement recommendation as discussed in the paperwork before you.
Okay. The only other option would be to make an oral motion to amend the indictment to change that, but
Given that, I'm comfortable with proceeding as a third degree, Your Honor.
okay. So what that means now, Mr. Vance, is that the paperwork's going to go through just like you signed it today, and it's going to say third degree felony.
Thank you, Your Honor.
All right, the court has reviewed the evidence. I do find that there's enough evidence to convict Mr. Vance of this offense. The court will follow the plea agreement. Court convicts Terry Glenn Vance of evading arrest or detention with a vehicle, a third degree felony. Assesses his punishment at 6 years confinement in TDC. Orders him to pay a fine of $5,000, restitution of $180, court cost of $290, reimbursement fees of $40. Court does dismiss under section 1245 CR 2140, possession of controlled substance of group 1 less than 1 gram. Mr. Vance, court will award you 232 days credit towards your sentence for the time that you spent in jail on this cause. I'm going to have you step over with a deputy to be fingerprinted. After that, you're remanded to the custody of the sheriff so he can carry out the conditions. Okay.
Thank you, Your Honor.
Thank you. All right, who else are you ready for, Mr. Singers?
Judge, you have Landon Musgrave for a plea.
All right, Landon Musgrave, cause number CR 287, CR 21267, 2021-226.
And Judge, he is entering a guilty plea to CR 20-00087, and then the other two causes are being 1245.
All right, thank you, sir. All right, Mr. Musgrave, if you'll raise your right hand, I'm going to place you under oath. If you go ahead and raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, let me put your hand down. Just make sure you speak up loudly and clearly for me so I can hear you. Your name is Landon Dwayne Musgrave, is that correct?
Yes, sir.
Mr. Musgrave, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss all of your cases with him and have all of your legal questions answered?
Yes, I do.
And is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Sanders, do you believe Mr. Musgrave to be competent today?
Yes, Your Honor, I believe he is.
And you've explained to him his legal rights with regards to all the cases?
Yes, Your Honor, I have. And Judge, just to let you know, I think we may have a similar problem with the judgment on Mr. Musgrave's case as we did with Mr. Vance, because it says third degree on the judgment, but there's actually an enhancement paragraph that would make it a second degree. You know, that just occurred to me since we just went through that with Mr. Vance's case.
Is it Mr. Musgrave's intention to plead true to the enhancement paragraph and plead to a second degree?
Well, that's what we'd anticipated. That's what the charge was. And the agreement time, amount of time fits within the third degree or second degree, either way.
Okay. Well, I guess the next question is the enhancement paragraph allegation true? I mean, have you looked through that cause to make sure that it was an assault of family or household by impeding breath or circulation? It wasn't reduced to class A or anything?
That was true. But it is true, Judge.
Okay. All right. So then, Ms. Heisel or Mr. Woodwike, I need this judgment on Mr. Musgrave to be modified to reflect that of a second degree felony.
Yes, Your Honor. I will fix that and bring it over to the court when we sign the paperwork.
And I'll need a plea of true to the enhancement paragraph. So a plea and a finding of true. All right, Mr. Musgrave, let's see here. You are charged by indictment with a third degree felony offense of possession of a controlled substance, penalty group 1, greater than or equal to 1 gram, but less than 4 grams. And the state has alleged a prior enhancement paragraph that, if proven true, would elevate the range of punishment to that of the second degree, which would carry a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice Institutional Division. I see here that the plea agreement in your case is that you would plead guilty to that offense, you would plead true to the enhancement paragraph, and the state would be recommending that your punishment be set at 8 years confinement in TDC with fines, court costs, reimbursement fees, restitution in the amount of $1,332.49. And you would receive 268 days credit towards your sentence for the time that you have spent in jail on this cause. And you would have 2 other cases dismissed in this plea. Those would be cause number CR 21267, an assault of a family or household member with previous conviction, and also 2021-226, which is a criminal mischief, $750 to $2,500. Is that your understanding of the plea agreement, Mr. Musgrave?
Yes, sir.
Yours as well, Mr. Sanders?
Yes, Your Honor, it is.
I appreciate you catching that issue for me, Mr. Sanders. All right, so Mr. Musgrave, at this time, I want to ask you, how do you plead to possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams?
Guilty.
Are you pleading guilty to that because you are guilty of committing that crime?
Yes, sir.
And as to the enhancement paragraph alleged in the indictment, is that the allegations in that paragraph true or not true?
True.
Are you pleading true because the allegations are true?
Yes.
All right, the court will accept the defendant's plea of guilt and his plea of true at this time. Mr. Sanders, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Yes, Your Honor. I will see if I can show for the court, just so Mr. Musgrave can see out at the jail that I have changed that to a second degree felony, and I have added the true to the punishment allegations. I'll bring this to the courthouse. Judge, additionally, Mr. Musgrave was arrested on November the 16th of 2021 for a new charge of aggravated assault with a deadly weapon. We are also taking that into consideration into this plea today. We have yet to receive a case from the Van Zandt County Sheriff's Office, so we don't have a file number to include on the face of the judgment. But we are putting on the record that we are going to take that into consideration. And as soon as we get that from the Sheriff's Office, our office will do a disposition, immediately releasing that charge from prosecution.
Thank you, Ms. Hodges. Anything further in the defense, Mr. Sanders?
No, Your Honor.
All right, the court's going to review the evidence. All right, the court's reviewed the evidence. I do find enough evidence to convict Mr. Musgrave of this offense. The court will follow the plea agreement in this case. The court convicts Landon Musgrave of possession of controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. Court finds his allegation in the enhancement paragraph to be true. Court finds that the range of punishment is elevated to that of a second-degree felony. Court assesses his punishment pursuant to the plea agreement at 8 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay a $2,500 fine, court costs of $290, restitution of $1,332.49, and reimbursement fees of $95. The court dismisses the criminal mischief and assault of a family or household member with previous conviction under section 1245. And the court awards Mr. Musgrave 268 days credit towards this sentence for the time that he has spent in jail on this cause. Mr. Musgrave, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you go with the deputy to be fingerprinted. Good luck to you.
Thank you, sir.
Mr. Sanders, you ready on the next one?
Yes, Your Honor.
And let's see, who are you ready on now?
Donald Ellis.
All right, Mr. Ellis. All right, this is CR 19305, State versus Donald Brian Ellis. And let's see, this is set for docket call, and I believe, Mr. Sanders, you filed a motion to dismiss indictment, is that correct?
Yes, sir. I was going to ask if we could have this set on the contested hearing docket. I assume there will be one later this month.
Yes, sir, there will be one on the 24th. All right, court will set Mr. Ellis's motion to dismiss indictment on February 24th, and that will be at 1:30, and that will be here in the courtroom. All right, are you ready on Mr. Harrell?
Yes, Your Honor.
All right, this is cause number CR 21263. Come on up, Mr. Harrell. All right, this is Mr. Harrell, and he's set for docket call. Go ahead, Mr. Sanders.
Judge, I believe we just, we had the issue about the CPS records, and I think the state has it. I think the court had a chance to review those, and so those have been made available to us. I was going to ask if we could reset this for one more docket call. Give me some time to go through that, talk to my client about that and some other matters as well with Mr. Harrell. If we'd be able to set it for another docket call.
Let me ask you, Mr. Sanders, have you been provided the records by the state?
No, not yet. I thought that I saw that they were on the online, and maybe not. Maybe I just misinterpreted what I saw in the online discovery.
I'm not sure that I've completed that review. Ms. Heisel, will you check your discovery portal and see if they have been disclosed? Then it's kind of moot, but
Let me check, Your Honor. I believe, because they all came on a disc, I believe what we did, and let me double check that this is correct, but I believe what we did was we scanned in the cover sheet just so Mr. Sanders would be made aware that we had received them, but I don't think those actually contain any of the documents.
I hadn't opened anything up. I just thought I saw something on the discovery portal, but
okay. Well, let's do this. I will set this for that same evidentiary day, 2/24, and then I'll bring you back a ruling on the records. I do have them. I've begun, but I've not finished.
okay. And Judge, we had also filed a motion for a bond reduction for Mr. Harrell. If we'd be able to address that on the 24th also.
Okay. I'll carry the request for bond reduction to that date as well.
Okay, thanks.
And Mr. Sanders, I don't show that those are on the portal, at least on my side. If it is, it's an error, so if you would just let me know.
Okay, all right, thanks. And I may have just seen something else and thought that's what it was. I don't know.
Okay, good. All right, we'll see you, Ms. Harrell. We'll see you back on the 24th. All right, Deputy McLeish, I'm going to bring in Wood County and Mr. Scott. They're zooming in. Wood County Jail is zooming in. Mr. Scott zooming in, and then I do have the attorney for Mr. Berry online. So I'm going to do this one real quick, and then we'll take care of Mr. Berry.
Yes, Your Honor.
All right, good afternoon. Mr. Veazey, can you see and hear me okay?
Yes, sir.
Okay, my name is Judge Chris Martin. I am the District Judge of the 294th District Court here in Van Zandt County. And Mr. Scott, John Scott is your attorney here in Van Zandt. Can you see and hear him okay? Introduce yourself, Mr. Scott.
And Mr. Veazey, John Scott here.
Okay, good. All right, I'm going to call this case. It's cause number CR 19-210, State versus Chad, Nathan Veazey. And we're set for a couple of things. One, I think we're set, I show arraignment. And then we were also going to discuss a possibility of trial settings in both Wood County and then also here in Van Zandt County. Mr. Scott, do you know, I know it's been quite a while, if we need to arraign Mr. Veazey, we can do that. I'm not sure that he's ever made an appearance here in our court for purposes of arraignment.
I don't recall an arraignment. He's been out for a long time, Your Honor. I don't recall if we ever did an arraignment. It might be safer just to do it. I mean, we can go ahead and take care of that if you'd like to.
Let me do that. Let me have it displayed here on the screen. All right, Mr. Veazey, can you see this document? Okay.
Yes, sir.
All right, I'm just scroll down and tell me when you're ready for me to scroll on up. You let me know. And I'll
scroll down. Okay. You scroll up. Okay.
All right, Mr. Veazey, I guess I should have looked that up. That back up there for you. Is your name spelled correctly in this document here in the middle part?
Yes, sir.
All right. And it appears that by indictment, you're charged with aggravated assault with a deadly weapon a second-degree felony offense that does carry a range of punishment if convicted and sentenced to a minimum of 2 years in prison to a maximum of 20 years in prison. Do you understand that full range of punishment?
Yes, sir.
And do you understand what you're being charged with here by your own reading of this indictment?
By reading this, yes, I understand.
Okay. All right. Mr. Scott, do you want to enter a plea for your client?
Yes, Your Honor. Well, I'll enter a plea of not guilty for Mr. Veazey.
All right. The court will enter Mr. Veazey's plea of not guilty into the record, and we will set this for a pretrial hearing. Prior to doing that, I'm assuming that we can still get the assistance of the Wood County Detention Center over there, the jail, on helping us make these Zoom hearings work. But I do need to set this for a pretrial so that Mr. Scott can have an opportunity to file any pretrial motion. So, Mr. Scott, are you available? I can set it out to say April 12th or 14th. And you could appear via Zoom on that day as well, Mr. Scott.
Your Honor, I'm available on April the 14th.
The 14th. All right, let's
Yes.
set this for April 14th, and that will be at 1:30, and we can do this via Zoom. And I'm going to go ahead and anticipate a special setting in this case. Check your calendars. The next available special setting that I have to set Mr. Veazey number one for trial would be October 31st. I understand that Mr. Veazey may have a trial before then in Wood County, and if he does, and that trial has any kind of effect on the case here in Van Zandt County, then obviously we could remove that or we could resolve it. Whatever the effect may be, we can take that up before October 31st. But if you're available, Mr. Scott, what I would like to do is go ahead and put Mr. Veazey number one that day.
I'm available, Your Honor. Let's go ahead and get that date, Your Honor.
All right, court will set Mr. Veazey then for jury selection on October 31st, and we'll have the whole week set aside for that case.
At 9 a.m. on the 31st, Your Honor.
Yes, I usually bring the jury. The jury will start arriving at 8, so yeah, 8:30 or 9. If Mr. Veazey is still in custody, then I'll have him over here about 8:30 or so.
Okay.
All right, and so if Mr. Veazey's case is not resolved in Wood County, then I will issue a bench warrant order to have him brought to Van Zandt. And Mr. Scott, I would say in anticipation of that, if you would like Mr. Veazey, let's say that his Wood County case is not resolved, he doesn't go to trial and it's still pending. If you would like him brought either here or probably even to Henderson County, I could potentially have him housed in Henderson County. That way it would be easier for you to have access to him. But at the very least, I know I can have him housed here in Van Zandt. I would do that so you and he could work on the case and you won't be hamstrung having to go to Wood County or deal with Zoom meetings.
I appreciate that, Your Honor. So I just need to get with you when it gets closer to trial.
Yes, sir. If you'll just let
Okay.
me or Ms. Tabraham know, that we'll make that work for the both of you.
Yes, sir. Thank you.
All right, so we'll see you back on the 14th, and my coordinator will work with Wood County on getting notice and asking them to set that up for us. Let's just, on that day, is it 3 o'clock better? Is that okay for you, Mr. Scott?
That's perfect if it's good for the court.
Yeah, let's do that at 3:30, or I'm sorry, at 3 as well, because I call mine at 1:30 and it gives us time to work through those. So we'll just do that at 3 o'clock.
Yes, sir.
And is the Wood County detention staff still available in the room, Mr. Veazey?
Yes, sir.
Okay, I just want to say I appreciate you guys helping out and making this work today for Mr. Veazey so that we could have this hearing. I appreciate you guys.
Yes, sir, no problem.
All right, we'll be adjourned in that case.
Thank you, Judge. Have a good day.
Thank you, Mr. Scott. I appreciate you, sir.
Sir.
Ms. Rachel, he's finished with that paragraph. If you just let us know when you're finished with it. He's good to go. Mr. DeBoer, when you're ready, you can take this.
Do you need him to sign any conditions or anything?
Hey, guys, we are on.
Good afternoon. Is it pronounced LaGrop?
Come on, Mr. Barry.
I think you're still on mute.
You did good, Your Honor. LaGrop, you got it right. 2 pieces like popcorn.
Well, no, I'll tell you, don't give me too much credit because I had to lean over and ask my coordinator, hey, how did he say this when you were on the phone with him? So I cheated a bit. I cheated a bit. So
Hey, we ought to be able to work this out. If Tyler and how would I sign plea papers? I mean, what do you want to do, Tyler? We ought to be able to work this out if you put us in a private room real quick.
I don't believe we'll be able to do it today. Mr. LaGrop and I had spoken previously. I had actually not written his name down because we don't have you as attorney of record. So if you would.
Go ahead. I thought I sent a letter of rep in.
We don't have anything. I believe the court doesn't either, because we had discussed previously that I had spoken to you. I just didn't recall what your name was. So if you would get with my office, we can get you all the discovery and everything for Mr. Barry, and we can finalize a plea arrangement in short order, get Mr. Barry resolved and on his way.
When is your next docket, Judge?
I've got February 22nd.
You want to do that because he's being considered for parole, because we ought to be able to work this out. He got 5 years TDC. I mean, I can go through the discovery, but we just, in case he can't get he's not gonna be able to really be considered for parole because of this case. And
Judge, if we'll set Mr. Barry for the 22nd, and Mr. LaGrop, if you will contact my office, we'll get you get your contact information. We'll get you your discovery so you can do your due diligence.
Okay.
And then I think we've already spoken about something less than 5. We can finalize the actual details and get Mr. Barry taken care of.
Yeah, I think because hold on a second. I just want to make sure something. I have everybody's email address right. I sent you the letter of rep was sent on January 24th. I sent it to y'all's email to Draham and to you on February 24th. You might want to look for it. Maybe it went to spam or something. I mean, not February, January 24th.
Yeah, and Mr. LaGrop, so Miss Tabraham is my criminal court coordinator, but she's not the clerk, so she's not gonna
Okay,
have
so
that
you want
file.
me to just e-file it? I mean, I normally just file an entry of appearance. I'll just file an entry of appearance.
Yeah,
That would be perfect. We'll get notification of that as well, and we'll get this taken care of.
Hey, and I apologize, y'all. A couple of the counties, when you file an entry of appearance, they go, "No, you didn't send us a letter of rep," and you're like, "Oh, I filed an entry of appearance." That makes me so. Every county's different, Judge. I do a lot. I'm from Houston. I do a lot of work all over, and however y'all do it's the way I do it. That's the way it works.
Yeah, if you'll just e-file that, that'll be fine, and we'll set Mr. Barry for a plea on 2/22, and that'll be at 1:30. And so I conduct the court dockets via Zoom. So you're welcome to come over. If you come to our jail, they'll let you in the back and you can meet with Mr. Barry. If you want to do that ahead of time and then appear.
That's what I'll do, Judge. That's
here later. That's fine.
No, that's what I'll do. I'll get up there ahead of time. And then if I get it all signed up, can I appear from here by Zoom and all that?
Yes, sir. Yes,
okay.
Sir.
Appreciate you, Judge. Hey, sorry for being a bother.
Hey, no problem. Get that done and we'll see you back on 2/22.
Okay.
All right. Thank you, Mr. Barry.
Thank you.
Miss Deputy McLeish, is Mr. Stevens out there yet?
I have not seen him yet, Your Honor.
I think he was coming from Kaufman. Yeah, I think he was still on his way from Kaufman. He let Patty know. So will be a holding pattern for him. And I believe is that everyone else except for Dallas Vigil, Caleb Tyndall, Jeremy Lewis.
We do still have Mr. Rodriguez in the room, Mr. Brad Rodriguez. It didn't sound to me like y'all concluded your business earlier. And we do have Mr. Gilliam on the way up.
Has Mr. Rodriguez completed his paperwork that Ms. Burns gave him? Ms. Burns gave him some paperwork, I believe, for court.
Ms. Burns is not here. We've got Ms. Matura's here.
Oh, okay. Let us resend that then.
Okay.
Oh, well, Ms. Burns said that she got it. She said it was okay, so I didn't know if she had sent it on or what. We need to send some paperwork out there. Who do we need to send it to?
Rachel Matura.
Okay. All right. Patty will resend it to Rachel. And then is Mr. Gilliam there?
He's on his way. He's on his way, but not here yet.
All right. Affidavit, please, do we have Billy Jack Gilliam III?
Mr. Gilliam? Yes, Your Honor, he is here. Come on up to the podium, sir.
Mr. Gilliam, you are here on a motion to revoke that's been filed by the state. I've reviewed your request for court-appointed attorney, and unfortunately for you, you do not meet the qualifications as being indigent based on your finances and expenses. So you're kind of left with two options. You can hire an attorney to represent you, or your family can hire an attorney, or you can represent yourself.
Okay, I don't have the money to, or the finances to hire an attorney. So I guess I would have to represent myself, but I don't know how that would really work. I've never done it before.
I mean, do you have any assets that you could sell, such as a car, anything of that nature?
Me and my wife, we have one car, and we have the kids at home, so can't really sell that at the time.
So you don't have any money saved up, you got no assets.
No, sir, I wasn't out that long, sadly, to build anything.
Well, I don't know what to do with you, Mr. Gilliam, because you don't meet under the law. Have you talked to your family about asking them if they can help you?
Yes, sir. They're not, like I said, I wasn't out that long, so they're not really trying to help much. So I'm kind of on my own on this one.
They disappointed in you or something?
Yes, sir. I am in myself too.
All right, well, have a seat. I'll look at it again.
Yes, sir. Thank you.
Mr. Rodriguez, available?
Yes, Your Honor, he's on his way up to the podium now.
All right, Mr. Rodriguez. Deputy McLeish tell you I was rather unhappy with your paperwork when you sent it in, that you just put zeros on everything.
Yes, sir.
She tell you I felt like that was a waste of my time.
Yes, sir.
It can't be zeros, because you're living. Somebody's feeding you, somebody's housing you, you had a job, you're getting to work somehow.
Yes, sir.
Don't waste my time, okay?
Yes, sir.
I'm going to appoint Mr. Stevens, your former attorney. I'm going to appoint him to your case again when he gets there. Okay, when he gets there. So when he walks in, he's not going to know that he's appointed to you because we haven't done that paperwork yet.
Yes, sir.
Okay, so we're going to get that done and we're going to let him know, and he may be able to talk to you a little bit today. But we're going to get your case reset when he gets there in a minute, okay?
Yes, sir. Thank you.
Have a seat.
as much as I could.
So just have a seat.
Good afternoon, Mr. Stevens.
Hey, Judge, how are you this afternoon?
I am doing fine. Are you ready to rock and roll?
Yes, sir. I'm sorry to keep you waiting. I didn't get out of Athens till, oh gosh, 3:20 or 3:30, something like that.
Yeah, those judges over there are terrible.
I know. Tell me about it. Oh, I guess we can do Dallas Vigil, Your Honor. It's a plea.
Sure, let's do that.
All right.
Vigil, if you'll come up. All right, Mr. Vigil, if you will raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down, speak up loudly and clearly for me. Your name is Dallas Anthony Vigil, is that right?
Yes, sir.
Mr. Vigil, are you a United States citizen?
Yes, sir, I am.
And do you read, write, and speak English?
Yes, sir.
And in this case, you're represented, well, let me ask you, have you ever been diagnosed with any type of mental disorder?
No, sir.
In this case, you're represented by Mr. Bill Stevens as your attorney. Do you feel like you've had enough time to discuss the case with him and have all your legal questions answered?
Yes, sir.
Are you pleased with him and his representation of you?
Yes, sir.
And where you've signed these documents today, you've only signed once you've read and reviewed and understand everything before you signed, right?
Yes, sir.
Mr. Stevens, do you believe Mr. Vigil to be competent today?
Yes, I do, Your Honor.
And have you explained to him his legal rights, and do you believe that he understands them?
I have, Your Honor, and yes, I do believe he understands.
Right, and I see that Mr. Vigil has two charges. One is an aggravated assault with a deadly weapon, which is a second-degree felony, and the other is a driving while intoxicated, Class A misdemeanor, blood alcohol concentration greater than 0.15. Mr. Vigil, on the aggravated assault case, that being a second-degree felony, the range of punishment must be within a minimum of 2 years to a maximum of 20 years, and a fine not to exceed $10,000. And on the Class A misdemeanor DWI, the range of punishment cannot exceed 1 year in the county jail and a $4,000 fine. Do you understand the ranges of punishment for each of these crimes?
Yes, sir, I do.
And Mr. Vigil, I see that the plea agreement with regards to the aggravated assault case is that you would plead guilty to that case in exchange for the state's recommendation that be reduced, let's see, reduced to I guess I'm a little confused. It says you're charged with aggravated assault deadly weapon, then it says plead to a lesser included offense of aggravated assault with a deadly weapon. I don't see that being a lesser.
I think that's a mistake in the papers, Your Honor.
What is the intention for it to say?
Well, we're intended to plead to the ag assault deadly weapon, the second-degree felony is what we're intended to plead to.
So you think the lesser included is incorrect?
Yes, sir, that is incorrect, I believe.
Judge, it was a ag assault in retaliation. We are dropping the retaliation part to just ag assault, not in retaliation, because ag assault in retaliation is a first-degree felony. Ag assault with a deadly weapon is a second degree.
So, Mr. Vigil, your plea would be to that charge. The state would recommend that you be convicted of that charge, that you be sentenced to 10 years in prison, but that sentence be suspended and you being placed on probation or community supervision for 3 years, along with fine, court costs, and reimbursement fees. Is that your understanding of the plea in that case?
Yes, sir.
And in your DWI case, the plea agreement is you plead guilty. They recommend 1 year in the county jail. They ask the court to suspend that sentence and place you on probation or community supervision for 2 years, with you paying fine, court costs, and reimbursement fees. Is that your understanding as well?
Yes, sir.
All right, so Mr. Vigil, I'm going to ask you at this time, how do you plead to aggravated assault with a deadly weapon, a second-degree felony?
I plead guilty, Your Honor.
Mr. Vigil, how do you plead to driving while intoxicated with a blood alcohol concentration of greater than or equal to 0.15?
Guilty.
Mr. Vigil, do you plead guilty to each one of these cases because you are guilty of committing each of these crimes?
Yes, sir.
Mr. Vigil, has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty to either of these?
No, sir.
Court will accept Mr. Vigil's pleas of guilt in each case. Mr. Stevens, any objection to the evidence from the state in both cases?
No objection.
The evidence from the state is admitted in both cases respectively. And the court takes judicial notice of Mr. Vigil's judicial confession. Anything further from the state, Mr. Woodbine?
No, Your Honor, we would rest and close.
Anything further from the defense, Mr. Stevens?
No, Your Honor, we'd also rest in close.
Take just a moment to review the evidence. Mr. Woodwhite, is there compliance with victim notification?
Judge, this is not my case. Well, let me take a look real fast.
Okay.
Judge, a victim impact statement was provided to the victim. We have not received any response back. State is in compliance with victim notification.
All right. All right, the court's reviewed the evidence. I do find enough evidence to convict Mr. Vigil of each of these offenses. The court does convict in CR 21251 of the offense of aggravated assault with a deadly weapon, a second-degree felony. Court assesses his punishment at 10 years confinement at TDC. Court will suspend that sentence and place him on community supervision for 3 years. Order him to pay a $2,500 fine, $290 court cost, $1,410 reimbursement fees. With regards to the DWI, cause number CR 21257, the state convicts him of driving while intoxicated with a blood alcohol concentration of greater than or equal to 0.15, a Class A misdemeanor. Court assesses his punishment at 1 year in the county jail, suspends that sentence today and places him on community supervision for 2 years, orders him to pay a $100 fine, $270 court cost, and $85 reimbursement fees. Mr. Vigil, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. You're going to go with the deputy to be fingerprinted, and then the probation officer will give you more information about the next step, okay?
Yes, sir.
Mr. Vigil, come with me, sir.
Mr. Stevens,
Yes, Your Honor.
I know you have another case, but I was going to ask you if I could give you an appointment today.
Yes, sir.
Mr. Brad Rodriguez, I believe that you represented him in the past,
I believe I have to.
and wanted to know if you would be willing to take that appointment from me today.
Yes, sir.
And I believe he is here on a motion to revoke. Yeah, I believe he's here on a motion to revoke, so I'll have Ms. Abraham send that order over, but if you want to go ahead and talk to him today, and then we'll reset that case.
Yes, sir, we can do that, Judge.
All right, are you ready on your other clients?
I am, Your Honor. Mr. Kendall, Caleb.
Caleb Rex Tyndall, CR 18227.
Come on, Mr. Stevens.
All right, Mr. Tyndall's here on a motion to revoke. So Mr. Tyndall here on a motion to revoke, I believe.
Yes, sir.
That is correct, Your Honor.
Any announcements, Mr. Stevens?
Judge, I was just appointed a week, 10 days ago, something like that. We're not ready to go forward, obviously. I haven't received an offer of punishment, and just today I received the motion to revoke. So we're asking respectfully for another court date.
Right, do you believe that 2 weeks would be insufficient time for you, Mr. Stevens? That's my next contested
I'd
docket.
like a little bit more time.
All right, the court will set Mr. Tyndall then for the contested docket on March 31st. And if an agreement is reached before that time, then you'll notify the court and we can set you sooner.
Yes, sir. Would that be at 1:30 or 9, Your Honor?
That will be at 1:30 and it'll be here in the courthouse.
All right, sir.
All right, you ready on Jeremy Lewis? Mr. Stevens, are you ready on Jeremy Lewis?
Jeremy Lewis?
Yes, Mr. Lewis was benched from TDC.
Sorry, Your Honor, I thought we had all the bodies in here, but we are missing one.
Maybe he can speak with Mr. Rodriguez for just a minute.
Absolutely, Judge.
Brad.
Deputy McLeish, is Mr. Gilliam still in there?
Yes, Your Honor, he is.
Yeah, you can go ahead and bring him up if you don't mind.
Come on up, Mr. Billy.
All right, Mr. Gilliam, I'm going to appoint an attorney to represent you.
Thank you.
I'm going to appoint Mr. Dustin Wilson. And I'm going to have some paperwork sent over to the jail. He'll have his phone number on there so that you can contact him. It may take a day or two before he receives the notification of the appointment. So he's not going to know anything about your case if you call him in the next couple of days. But nevertheless, you need to call him and you need to introduce yourself so that y'all can build that rapport and start that attorney-client relationship, okay?
Yes, sir.
And I'm going to reset you for, I'm going to set you on March 31st on the contested docket. And if Mr. Wilson gets on your case and y'all work something out before then, he can always ask me to set it sooner and we can hear your case quicker, okay?
Yes, sir. Thank you, Judge. Okay. Lewis.
All right, Mr. Stevens, who are you ready on?
Jeremy Lewis, Your Honor.
All right, Mr. Lewis, if you'll step up. And do you need me to display Mr. Lewis's indictment? I don't think.
No, Your Honor, I have it. Excuse me, and we've already gone over it.
Okay, go ahead then. This is CR 2180 State versus Jeremy DiCardo Lewis.
If I may please the court, Your Honor, Mr. Lewis would advise the court that his name is spelled correctly. He understands the nature and the consequences of the charges against him. We will waive reading of the indictment, enter a plea of not guilty.
All right, the court will enter Mr. Lewis's plea of not guilty into the record. We'll set this matter for pretrial. And I think the next pretrial dates I have, Mr. Stevens, are March 8th and 10th. I can't recall what your schedule is.
Let me look real quick. I'm in here on the 8th.
All right, do you want me to go ahead and set Mr. Lewis on the 8th, or is that not enough time?
No, sir. Please go ahead on the 8th.
All right, we'll set him March 8th. And DA's office, if you can just make sure that the discovery portal is open to Mr. Stevens, if it's not already.
I'm looking into that right now, Judge.
Thank you, sir.
And Tyler, if you could send over some kind of offer for me along the way so I can discuss it with my client.
Yes, sir, I will.
Thank you.
All right, Mr. Lewis, we'll see you back on March 8th. And are you ready on Mr. Moreno?
Judge, I didn't know I had a Mr. Marino.
It's writ seeking bail reduction.
No, sir. I don't believe that's mine. Yeah. Yeah, I didn't follow it. Your Honor, I don't have his file with me. I didn't know that Mr. Moreno was sent today.
Let me double check here.
I didn't see it on the docket that I printed out here a few days ago.
Yeah, it looks like you filed your writ early January. We sent out a notice on January 14th. I mean, we could reset it today, but yeah, we
Judge, I don't have my file. I'm not ready for it.
Judge, before we do that, the state is going to agree to Mr. Stevens' writ. Mr. Moreno, however you say his name, I don't mean to mispronounce it, has been in for 90 days. We still don't have, he's been arrested on 3 charges. We don't have a single one. It's my understanding he's been in for 90 days. State would be unopposed to the writ if Mr. Stevens will provide the court and my office an order. State would be unopposed because we don't have anything. I can see from the jail list that he was arrested November 13th for ag assault, burglary of habitation, and unlawful possession of firearm by a felon, but we have no case. Okay. We don't have any of those. We don't have anything.
When I get back to my office, I'll pull the file and ship over the order to you.
Well, and Mr. Stevens, I believe you already did that when you filed the writs, because I've got 3 orders here with each one. So, and what are you agreeing to, or what are you asking for it to be set at, Mr. Stevens, so I know what Mr. Woodwhite's agreeing to?
Well, Your Honor, we can leave them set at whether they are if the state's going to agree to PR bonds.
Okay. All right, it's 150 and 20. So I will sign those orders, allowing him to post personal bonds then on those charges.
Thank you, Judge.
Thank you, Judge.
Mr. Stevens, just tell me when you're ready. Mr. Rodriguez.
I'm ready now, Judge.
Okay, go ahead and bring them up. All right, Mr. Stevens, court appreciates you accepting this appointment for Mr. Rodriguez. He indicated to me that you previously represented him. He thought that you were still going to represent him, and I had to explain to him that the underlying charge and the subsequent motion to revoke were two separate criminal cases. And so it just so happened that you were coming over, so I thought a convenient thing would be to appoint you to that case. So Mr. Rodriguez is here on a motion to revoke due to your appointment today. I know that you're not ready. You haven't had a chance to hardly speak with him or review the information. So I will reset Mr. Rodriguez then for a revocation hearing on March 31st. And if y'all reach an agreement on something to resolve the case sooner, you'll let me know and I can schedule you. And you're fine with that date, correct, Mr. Stevens? I thought we set another one up for the 31st for you. Is that right?
31st is fine, Judge.
Okay. And that'll be at 1:30 here in the courthouse.
All right, sir. Thanks for filling up the reset notices. I didn't know if I was going to make it here. It's crazy on doing it happens.
Will you be getting this particular case copy or?
No.
We'll let you know when your next thing is, make sure you make it. You think you're gonna be bonding out at all? Okay.
Thank you, ma'am. See you next time.
We'll see ya.
Deputy McLeish,
Yes, Your Honor.
do we have anyone else at the jail that needs a judicial official to meddle in their lives?
I think you saw every person in the jail today. I don't think there is anybody left.
I think you're right. So, all right, we will be adjourned. Thank you for your help. Tell the jail staff I appreciate their help. And we'll,
Certainly will, sir.
we'll air at the same time, same YouTube channel. Don't forget to subscribe.
Roger that. Thank you.
Smash that like